Welcome back to the deep dive. I have a stack of documents in front of me today that feels a little bit like a script for a psychological thriller.
Yeah, it really does.
We've been digging through military court appeals from the early 1960s, specifically looking for cases that, break the logic of how we understand crime. And we found one.
We certainly did. This is a case that has tormented law students and, well, legal philosophers for decades.
The case is United States v. Thomas from 1962. But really, our mission today is broader than just one court case. We're using this story to explore a fundamental crack in the legal system.
The boundary between a criminal mind and a criminal act.
Exactly. What happens when a person is 100% committed to doing something evil, but reality itself makes the crime physically impossible?
It forces us to answer a very uncomfortable question. Do we punish people for the harm they actually cause, or do we punish them for the darkness in their hearts?
So settle in. We are going to verify the facts, unpack the legal theories, and stare into the abyss of impossible attempts. Let's start where all good legal dramas start. A bar in 1962. Set the scene for us.
Okay, so Saturday night, we're dealing with three young sailors, Thomas, who is 20, McClellan, 19, and Bruzy, who's 18. They're out bar hopping, looking for a good time.
And they find a place.
They do. They land at a tavern called Taylor's Place.
And this is where this sequence of events gets incredibly specific and tragic.
Right. McClellan spots a young woman. They start dancing. The music is playing. People are drinking. And then in the middle of the dance, she just collapses. She drops right into his arms.
Now, at this point, the sailors assume the obvious.
That she's had too much to drink. She's passed out.
So they do what looks like a good deed. They volunteer to take her home. They carry her out to McClellan's car.
But once they're in that car, the good deed just evaporates.
It takes a very dark turn.
It does. They can't find her house.
Hmm?
And McClellan, using what the court record politely calls frank, expressive language, suggests that since she's unconscious, they should take advantage of the situation.
Basically, they decide to rape her. They think she's just drunk and I'm quoting here, would never know the difference.
Exactly. It is a conspiracy to commit rape. The record is clear that while they were driving around, each of the three men either committed sexual acts or attempted to consummate sexual acts with her in the back of the car.
But then reality crashes the party.
It does. They can't wake her up. Panic sets in. They stop at a service station and call the police. The police arrive, examine the girl, and deliver the news. She's dead.
But here's the crucial part. The detail that turns this from a standard tragedy into a massive legal puzzle.
The autopsy. It revealed she didn't die in the car. She died of acute interstitial myocarditis, basically massive heart inflammation. And the medical examiners determined she died the exact moment she collapsed on the dance floor at Taylor's Place.
Wait, let me just pause there to make sure everyone really gets this. Before they put her in the car, before they even had the idea to assault her, before they touched her, she was already a corpse.
Correct. Biologically, she was deceased before any crime was even proposed.
That's horrifying. But it also creates the legal problem we're here to solve. They were charged with attempted rape.
Right. But the defense lawyers looked at this and said, hold on a second. You cannot rape a dead body. A corpse is not a person under the law. Rape is a crime against a person.
So they argued it was legally impossible for them to commit rape.
And if it's impossible to do the crime, you can't be convicted of attempting to do it. That was their whole argument.
And the Board of Review, the lower court, actually bought this argument, didn't they?
They did. They threw out the conviction. They reasoned that since there was no living victim, there could be no rape. It didn't matter what the sailors thought they were doing. Reality said no crime occurred.
So the government appealed this to the Court of Military Appeals, and that's where our deep dive focuses. But before we see how the High Court fixed this, or didn't fix it, we need to understand the tools they were working with.
We need a crash course in the law of attempts.
Let's do it. Broadly speaking, before we get to all the impossible stuff, what does the law require to convict someone of an attempt?
The general rule of attempt has three classic pillars. First, you need specific intent. You have to really, truly mean to commit the crime. Accidents don't count.
Okay, intent.
Second, you need an overt act. You can't just think about it. You have to take a substantial step toward actually doing it.
And the third pillar.
Traditionally, the third element was apparent ability or the failure to consummate the crime. You had to be close enough to success that it was a real threat.
Okay, so if I intend to rob a bank and I walk into the bank with a gun, that's the overt act, but the teller tackles me before I get any money, I'm guilty of attempt.
Oh, yeah. Easy conviction.
But our sailors have a problem with that third pillar. They had the intent. They had the overt act. But they had zero ability to commit rape because the victim was dead.
And this leads us straight to the doctrine of impossibility.
Right. And you mentioned there are two flavors of this.
Yeah.
Factual impossibility and legal impossibility.
This is the most critical distinction in this area of law. And, one of them gets you sent to prison, and the other one traditionally lets you walk free.
Let's break these down with some visceral hypotheticals. I want to play a bit of a game here to test the boundaries. I'm going to give you a scenario from the legal case books, and some of these are wild, and you tell me if it's factual or legal impossibility and whether the guy goes to jail.
I'm ready. Lay him on me.
All right, scenario 1. This is the classic. Commonwealth v. McDonald. I am a pickpocket. I see a man on the subway. I see a bulge in his pocket. I reach in, expecting a wallet. I grab. Nothing. The pocket is empty.
That is factual impossibility.
And the verdict.
Guilty of attempted larceny.
But why? I didn't steal anything.
Because the law says your intent was perfect and your act was perfect. The only reason you failed was a random fact of the world, the empty pocket that you didn't know about. You are dangerous, so you are guilty.
Okay, that makes sense. Now let's get weirder. Scenario 2. State v. Guffey. I'm a hunter. It's illegal to shoot deer out of season. I see a deer standing by a tree. I check my scope, I pull the trigger, boom, perfect shot. But when I walk up to it, it turns out it's a stuffed deer. A dummy hide filled with straw that a taxidermist put there as a joke.
Ah, the famous stuffed deer case. Under the traditional old world rules, this is legal impossibility.
And the verdict.
Not guilty.
Whoa, wait. I thought I was killing a deer. I shot at it. Why am I not guilty?
Because it is not actually a crime to shoot a targeted collection of straw and hide.
Yeah.
In the eyes of the law, you shot a dummy. Even though your mind was guilty, your act was perfectly legal. You can't be convicted of attempting to do something that isn't actually a crime.
That feels like a massive loophole. The guy with the empty pocket goes to jail, but the guy shooting the stuffed deer walks free. They both fail because of a mistake.
It creates a huge tension. The empty pocket is a fact stopping you. The stuffed deer is a legal status stopping you. It's a very fine line.
Okay, one more. People v. Lee Kong. I'm an assassin. I think a policeman is spying on me through a hole in the roof. I aim my gun at the hole and fire, intending to kill him. But the policeman had moved 5 minutes ago. I just shot a hole in the air.
This is factual impossibility. Verdict. Guilty of attempted murder.
Because the policeman could have been there.
Exactly. The victim existed. The gun was real. You just got the location wrong. That's a factual error, not a legal one.
Okay, last one. This is crucial for the Thomas case. People v. Jaffa. I want to be a criminal offense. I buy a bunch of cloth from a guy who tells me it's stolen. I believe him. I buy it intending to resell stolen goods. But actually, the cloth wasn't stolen.
This is the classic legal impossibility defense, just like the stuffed deer. Verdict. Not guilty under the traditional view.
Because you can't receive stolen property if the property isn't stolen.
Precisely. And this is the exact logic the defense used for the Thailers, they said. Just as you can't receive non-stolen goods, you can't rape a non-living woman. It's a legal impossibility.
So the Court of Military Appeals in Thomas had to decide. Is raping a corpse more like picking an empty pocket, which is a crime, or shooting a stuffed deer, which wasn't?
That is the million-dollar question.
Let's analyze United States v. Thomas. We need to be rigorous here. We're going to break this down element by element. First, what are the legally dispositive facts?
The accused sailors took an unconscious female from a tavern. They engaged in sexual intercourse, or at least attempted to. The female was dead at the time of the acts due to heart failure. Crucially, the accused did not know she was dead. They believed she was drunk. The Board of Review set aside the conviction for attempted rape, citing legal impossibility.
And what was the core legal issue?
The issue is whether the fact that the victim was dead prior to the sexual acts constitutes a defense of legal impossibility to a charge of attempted rape, where the accused believed the victim was alive.
Okay, here is the pivot point. What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court rejected the rigid distinction between legal and factual impossibility. They adopted the modern view, which aligns with the model penal code. The rule is this: an accused is guilty of an attempt if, acting with the kind of culpability otherwise required for the crime, he purposely engages in conduct which would constitute the crime if the attendant circumstances were as he believes them to be.
Okay.
The rule has 3 elements. 1, culpable intent, meaning the specific belief and desire to commit the crime. 2, an overt act. And 3, the immateriality of impossibility, which is that attendant circumstances test.
If the attendant circumstances were as he believes them to be, that is such a heavy phrase. It basically means we're going to judge you based on the movie playing in your head, not what's happening in the real world.
Exactly. It creates a simulation of the crime based entirely on the accused's belief.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, culpable intent?
Okay, so the sub-issue here was whether the sailors actually had this specific intent to rape. The sub-rule is that intent is subjective. It's what the actor is thinking. The court looked at the facts. McClellan and Thomas used that frank, expressive language. They explicitly said they thought she was just drunk. They intended to have non-consensual intercourse with a living woman. So the court concluded this element was met. Their minds were guilty.
Understood. They wanted to do it. Now, what about the second element, the overt act?
So the sub-issue is whether they took a substantial step. And the sub-rule is that the act has to corroborate the intent. Here, the application is, well, graphic but simple. They physically engaged in sexual acts with the body. They didn't just talk about it, they did it.
So element met.
The court concluded this element was met, no question.
Okay, now we get to the main event. The third element, the immateriality of impossibility. How did they get around the stuffed deer defense?
This is the groundbreaking part.
Yeah.
The sub-issue is whether the victim's death even matters. The sub-rule comes from that model penal code attendant circumstances test. The court essentially said, let's pretend the facts were what the sailors thought they were.
So in their heads.
In their heads, she was alive. So the court asks, if she had been alive, would their actions be rape? And the answer is obviously yes. The court argued that distinguishing between factual and legal impossibility just leads to absurd results. That a man who shoots a dummy thinking it's a person is just as dangerous as a man who shoots a real person.
So the impossibility of the crime becomes
Irrelevant. The defense was rejected. Element met.
So they completely obliterated the stuffed deer loophole.
They burned it to the ground. They decided that the classification of the impossibility doesn't matter. All that matters is, did you try to do it?
And after analyzing all the elements, what was the court's final conclusion?
The Court of Military Appeals reversed the board of review. The conviction for attempted rape was reinstated. The holding establishes that in modern military jurisprudence, and now most modern U.S. law, impossibility is not a defense if the crime was possible under the facts as the accused believed them to be.
That is a massive shift in how we think about justice. We moved from no harm, no foul to guilty mind, guilty man.
But we should mention this wasn't unanimous. There was a very loud dissent from a Judge Ferguson.
I was reading that. He seemed genuinely angry about this new rule. What was his problem with it?
Judge Ferguson argued that by rejecting legal impossibility, the court was crossing a line into punishing sinful thoughts. He basically said, look, sex with a corpse is gross, it's immoral, but it is not rape. If you punish these men for attempted rape, you are punishing them for a hallucination.
He used some colorful examples too, right?
He did. He warned that under this new rule, we could end up punishing people for attacking logs or dressmakers' dummies. He believed that if there is no victim in being, no actual person to be hurt, the state has no business stepping in with a felony charge.
But the majority said, we don't care about the log, we care about the guy swinging the axe.
Precisely.
Okay, let's zoom out. For the listener who is trying to keep this straight, maybe they're a law student, maybe they just want to win an argument. How do we synthesize this? Can you give us a checklist?
Absolutely. If you run into a case where someone tries to commit a crime but fails because it was impossible, follow this three-step diagnostic.
Step 1.
Step 1. Identify specific intent. Ask yourself, did the defendant intend to commit a specific crime defined by law? If they didn't mean to break the law, stop there. In Thomas, they intended rape. Simple.
Step 2.
Step 2. Identify the overt act. Did they take a substantial step? Did they pull the trigger, reach into the pocket, or start the assault?
And step 3, the fork in the road.
Right. Step 3. Analyze the impossibility. First, check if it's factual impossibility. Did they fail because of a physical mishap like a gun jamming or an empty pocket?
And if the answer is yes.
Always guilty. Doesn't matter what year it is, you are going down.
And if it's not factual.
Then you are in the legal impossibility danger zone.
Yeah.
Did they do exactly what they wanted, but it wasn't a crime because of legal status? A stuffed deer, a dead body, non-stolen goods.
Okay.
Here you have to check your jurisdiction. Under the old rule, common law, not guilty. But under the modern rule, Thomas Model Penal Code, guilty. Just apply the attendant circumstances test. If the world were as the defendant believed it to be, would they be guilty? If yes, convict them.
That is incredibly clear. And it shows just how much the law depends on when and where you are tried. In 1950, these sailors might have walked. In 1962, under this modern view, they went to the brig.
It represents the evolution of law from a purely physical system to a psychological one.
Before we close up the file, I want to go back to Judge Ferguson's dissent one last time. He warned about the never-never land of punishing people for impossible things. If we take the Thomas rule, this attendant circumstances rule, to its absolute logical extreme, are we effectively punishing voodoo?
That is the ultimate law school hypothetical. Let's say I hate you, I make a doll of you. I genuinely 100% believe that if I stab this doll with a needle, you will die of a heart attack. I have the specific intent to murder you. I perform the overt act of stabbing the doll.
And under the old rule,
You're just a guy with a doll, not guilty. It's a classic legal impossibility.
but under the Thomas rule, under the model penal code.
Well, let's run the test.
Okay.
If the attendant circumstances were as the accused believed them to be,
Hmm.
meaning if voodoo actually worked, would it be murder?
Yes.
Yes. Therefore, theoretically, you are guilty of attempted murder.
So the law has evolved to the point where we could theoretically put someone in prison for stabbing a doll purely because they thought it would work.
It sounds absurd, but that is the price we pay for switching to a system that focuses on the dangerousness of the mind rather than the outcome of the act. The sailor attacking a corpse and the voodoo practitioner stabbing a doll both think they are killers. The modern law decides to take them at their word.
That is a fascinating, slightly terrifying place to leave it. We've gone from a tragic death on a dance floor to the metaphysics of voodoo.
Just remember, under modern law, your thoughts, when coupled with action, can be just as illegal as the result.
That's it for this deep dive into United States v. Thomas. Thanks for listening.